Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People ex rel. Andrew Ellis v. Kirk Imperati, decided on June 17, 2025. Halligan, J. Michael Cavagnolo was arrested and charged with making a terroristic threat after he repeatedly called the Hyde Park Police Department emergency line threatening to commit violent acts against officers, their families, and police department property. County Court fixed bail pursuant to CPL 510.10(4)(a). That paragraph makes bailable all violent felony offenses listed in Penal Law Section 70.02, with two specific exceptions. One of the offenses listed in Penal Law Section 70.02 is the crime of making a terroristic threat. See Penal Law Section 70.02, 1c, paragraph G, of CPL 510.10(4). However, makes bailable the felony crimes of terrorism defined in Penal Law Article 490 but expressly excludes the crime of making a terroristic threat. Although these two paragraphs are difficult to reconcile, the text and disjunctive structure of CPL 510.10(4) indicate that paragraph G was not intended to narrow the independent authorization provided in paragraph A to set monetary bail for all violent felony offenses listed therein. We therefore hold that making a terroristic threat is a bail-eligible offense. Accordingly, we reverse. 1. In March 2024, Mr. Cavagnolo was arrested and charged with one count of making a terroristic threat in violation of Penal Law Section 490.20. The felony complaint alleged that in a series of calls to the Hyde Park Police Department emergency line, Mr. Cavagnolo made repeated threats of violence, including to the police dispatcher and her family. He threatened to shoot police officers, to use hand grenades, guns, and gasoline on the police department, and to blow up department property. The Bill of Particulars additionally alleges that after his arrest, while at the booking area of the police precinct, Mr. Cavagnolo told the officers that he would shoot them in the head and would kill them and their families. County Court determined that making a terroristic threat constitutes a bail-qualifying offense pursuant to CPL 510.10(4)(a), and set bail. Petitioner commenced this habeas corpus proceeding, contending that the offense does not qualify for bail because it is explicitly excluded under paragraph G of subdivision 510.10(4). The Appellate Division granted the petition and ordered Mr. Cavagnolo's release. The court held that even though the crime of making a terroristic threat is defined by statute as a violent felony, the authority conferred by CPL 510.10(4)(a) to set bail for violent felony offenses does not extend to this particular offense because CPL 510.10(4)(g) explicitly excludes it. According to the Appellate Division, paragraph G is a more specific provision than paragraph A, and therefore controls, and the contrary reading would render paragraph G's exclusionary language superfluous. One justice dissented, explaining his view that the specific trumps the general canon does not apply because both paragraphs A and G are specific. A specifically identifies Penal Law Section 490.20 as a bail-qualifying offense by incorporation of Penal Law Section 70.02, and paragraph G specifically identifies Penal Law Section 490.20 as not qualifying. The dissent concluded that the statute authorizes trial courts to fix bail for the crime of making a terroristic threat, and that the opposite conclusion was objectionable given the nature and severity of the crime. Mr. Cavagnolo ultimately pleaded guilty to one count of making a terroristic threat and was sentenced to 5 years of imprisonment and 5 years of post-release supervision. This court granted the people leave to appeal. 2. Paragraphs A and G of CPL 510.10(4) were adopted in 2019 as part of sweeping bail reform that eliminated cash bail for all but a set of specified crimes. For those crimes, termed qualifying offenses, the court has the discretion to fix bail, or order non-monetary conditions in conjunction with fixing bail, CPL 510.10, 4. For all other crimes, the court must release the defendant on their own recognizance, or, if the court finds that will not reasonably ensure the defendant's return to court, release the defendant under non-monetary conditions, CPL 510.10, 3. Qualifying offenses are set forth in 21 separate paragraphs, each of which describes the particular category of crime for which bail may be imposed. Paragraph A makes bailable violent felony offenses, with 2 express exceptions. It does so by reference to Penal Law Section 70.02, which enumerates a list of such offenses. Paragraph A states, a principal stands charged with a qualifying offense when he or she stands charged with a felony enumerated in Section 70.02 of the Penal Law, other than robbery in the second degree as defined in Subdivision 1 of Section 160.10 of the Penal Law, provided, however, that burglary in the second degree as defined in Subdivision 2 of Section 140.25 of the Penal Law shall be a qualifying offense only where the defendant is charged with entering the living area of the dwelling, CPL 510.10, 4a. Among the violent felony offenses listed in Penal Law Section 70.02 is making a terroristic threat in violation of Penal Law Section 490.20. The offense with which Mr. Cavagnolo was charged, see Penal Law Section 70.02, 1c. As originally enacted, Paragraph A of CPL 510.10, 4, included 2 exceptions providing that second-degree robbery and second-degree burglary, despite being listed in Penal Law Section 70.02, did not qualify for bail. The provision was amended a year later to allow bail for second-degree burglary if the defendant is charged with entering the living area of the dwelling, while continuing to exclude all other charges of burglary in the second degree. Paragraph G of CPL 510.10, 4, makes the following terrorism-related crimes qualifying offenses. Money laundering in support of terrorism in the first degree as defined in Section 470.24 of the Penal Law, money laundering in support of terrorism in the second degree as defined in Section 470.23 of the Penal Law, money laundering in support of terrorism in the third degree as defined in Section 470.22 of the Penal Law, money laundering in support of terrorism in the fourth degree as defined in Section 470.21 of the Penal Law, or a felony crime of terrorism as defined in Article 490 of the Penal Law, other than the crime defined in Section 490.20 of such law, CPL 510.10, 4g. 2 of these money laundering offenses, money laundering in support of terrorism in the third degree as defined in Section 470.22 of the Penal Law and money laundering in support of terrorism in the fourth degree as defined in Section 470.21 of the Penal Law, were not included in Paragraph G, as originally enacted, but were added by the legislature at the same time it amended Paragraph A, to make bailable second-degree burglary if the defendant allegedly entered the living area of the dwelling. None of the amendments to CPL 510.10, 4, either in 2020 or subsequent years, address the crime of making a terroristic threat. 3. This review of the statutory text makes plain the question presented: is the crime of making a terroristic threat bailable, where Paragraph A of CPL 510.10, 4, includes the offense, but Paragraph G excludes it. Put differently, did the legislature mean to import Paragraph G's exclusion into Paragraph A? As with any question of statutory interpretation, our task is to ascertain and give effect to the intention of the legislature. Matter of Town of Southampton v. New York State Department of Environmental Conservation, quoting matter of Mestecchi v. City of New York. We start with the text, which is the clearest indicator of legislative intent, id, quoting Kuzmich v. 50 Murray Saint Acquisition. When the statutory language at issue is but one component in a larger statutory scheme, It must be analyzed in context and in a manner that harmonizes the related provisions and renders them compatible. Matter of NYPTI. Our duty, after all, is to construe statutes, not isolated provisions. King v. Burwell. CPL 510.10, sets forth a disjunctive list. Each paragraph is separated from the others by a semicolon, and the final two paragraphs are separated by the word or. See CPL 510.10, T.U. Canons of construction ordinarily suggest that terms connected by a disjunctive be given separate meanings, unless the context dictates otherwise. Ryder v. Sonotone Corporation. See also Garcia v. United States, noting the terms at issue are made separate and distinct from one another by Congress' use of the disjunctive. Critically, elements in a disjunctive list are typically not intended to modify each other, as doing so would rob an element of its independent and ordinary significance. Ryder. Here, this disjunctive structure confirms that the legislature intended each paragraph in CPL 510.10, including A and G, to set forth a separate and distinct category of offenses identified as qualifying for purposes of monetary bail. One paragraph does not modify another. Further support for this view is found in the substance of the items on the list and the way they interact, as against relevant background understandings. Pulsifer v. United States. CPL 510.10, lists 21 categories of bailable crimes, each independent of the others and serving a distinct concrete function. Paragraph. A.'s function is to make bailable the violent felony offenses enumerated in Penal Law Section 70.02, with the express exceptions of second-degree robbery and certain second-degree burglary offenses. There is no indication that the legislature intended to dilute that objective by importing an exclusion from a different paragraph dealing with a different category of crimes. Other features of the statute confirm that the legislature intended each paragraph to stand alone, and did not intend CPL 510.10, to be read as a conjunctive whole. First, there is significant overlap among various paragraphs in CPL 510.10. For example, paragraph D includes Class A felonies defined in various provisions of the penal law, and several of those felonies are also separately set forth in paragraph G. Compare CPL 510.10, D, deeming bail eligible certain Class A felonies defined in the penal law including violations of Penal Law Sections 490.27, 490.28, 490.45, 490.50, and 490.55, with CPL 510.10, G, deeming bail eligible violations of Penal Law Sections 490.27, 490.28, 490.45, 490.50, and 490.55 by reference to Penal Law Article 490. Similarly, certain felony sex offenses enumerated in paragraph E are also violent felony offenses deemed bailable by paragraph A. See for example Penal Law Section 230.34a, sex trafficking of a child, or Class A felony offenses bailable under paragraph D. See for example Penal Law Section 130.96, predatory sexual assault against a child. These redundancies suggest the legislature did not consider how each of the paragraphs relate to each other, making it unlikely that it meant for an exclusion included in one paragraph to be engrafted onto another. Second, the inclusion of exceptions and qualifications in numerous paragraphs, see CPL 510.10, 4, D, F, G, H, K, P, T, reflects careful and discrete consideration of each paragraph's scope and any appropriate exceptions. Paragraph A offers an example. The legislature initially excluded second-degree robbery and burglary from the list of qualifying violent felonies, and then further refined that list in a 2020 amendment by restoring second-degree burglary with entry into a living area as a bailable offense. At the same time, the legislature also amended paragraph G to include additional money laundering offenses in support of terrorism. Had the legislature intended to exempt making a terroristic threat from the violent felonies covered by paragraph A, it could have said so explicitly in that paragraph, as it did by carving out the exceptions for second-degree robbery and certain second-degree burglary offenses. See Stefanik v. Hochul. The inclusion of provisos or exemptions is generally considered to deny the existence of others not mentioned. Alternatively, the legislature could have expressly instructed that paragraph G's exclusion of the crime applies throughout CPL 510.10, 4, notwithstanding conflict with another paragraph. But the legislature did neither. Given those drafting choices, it seems unlikely that the legislature intended to implicitly import paragraph G's exclusion into paragraph A. The legislative history of Penal Law Article 490 and CPL 510.10, 4, offers no basis for a contrary view. Article 490 was enacted immediately after September 11, 2001. Intended to ensure that terrorists, as well as those who solicit or provide financial and other support to terrorists, are prosecuted and punished in state courts with appropriate severity, it criminalizes certain terrorism-related activities. The article's legislative history does not discuss bail. As noted, CPL 510.10, 4's current framework for setting bail was enacted in the 2019 Bail Reform Bill. The subdivision initially included 9 paragraphs, each enumerating a different category of crimes for which a trial court could set bail. That list was expanded to 21 paragraphs through subsequent amendments. Nothing in the legislative history of these amendments addresses the terrorism-related offenses included in paragraph G. We address several additional points made by the dissent and the appellate division. Each relies on the principle that a general provision must yield to a specific one, but close examination reveals that can and does not apply here. Neither paragraph A, nor G, is general. Each paragraph includes a reference to the specific crime of making a terroristic threat. The only distinction is that one does so by incorporation via Penal Law Section 70.02, which enumerates violent felonies, and the other directly references the offense. That difference does not make the first general and the second specific. The dissent also argues, and the appellate division concluded that if paragraph G's exclusion does not apply to paragraph A, then the exclusion is superfluous. See dissenting op. At 10 to 12. But as we have explained, each paragraph of CPL 510.10, 4, confers distinct authority to set monetary bail for the qualifying crimes identified in that particular paragraph. The exclusion in paragraph G simply means that authority to impose bail under that paragraph because an offense is a crime of terrorism does not extend to the crime of making a terroristic threat. At the same time, paragraph A confers authority to impose bail for all violent felonies as defined in Penal Law Section 70.02, including making a terroristic threat, with the specific exceptions of second-degree robbery and certain second-degree burglary offenses. Given this statutory structure, which evinces independent determinations about different categories of offenses, we see no indication that the legislature intended paragraph G's exclusion to supersede the authority expressly granted in paragraph A, to treat making a terroristic threat as a bailable offense. 4. In conclusion, we hold that CPL 510.10, 4a, authorizes a court to set monetary bail for a person charged with making a terroristic threat under Penal Law Section 490.20. Petitioner's argument that the appellate division erred in imposing non-monetary conditions when ordering Mr. Cavagnolo's release is not properly before us and we do not consider it. See Odin v. Chemung County Indus Development Agency. Accordingly, the appellate division judgment should be reversed, without costs, habeas corpus proceeding converted to a declaratory judgment action and judgment granted in accordance with this opinion. Judgment reversed, without costs, habeas corpus proceeding converted to a declaratory judgment action and judgment granted in accordance with the opinion herein. Opinion by Judge Halligan. Judges Garcia, Singas and Canataro concur. Chief Judge Wilson dissents in an opinion, in which Judge Troutman concurs. Judge Rivera dissents, joins sections 1, 2, a, 3 and 5 of the dissenting opinion, and further agrees that the majority's construction renders language in CPL 510.10, 4G, superfluous. Decided June 17, 2025.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law